Today we are going to discuss in this lecture the sexual harassment at workplace. The main objective of this lecture is to understand the concept and meaning of sexual harassment at workplace, how diverse location that constitutes the offense relating to the sexual harassment. It illustrates the forms of sexual harassment at the workplace and the extent of their prevalence in India and elsewhere. How legal response and social action taken place. Sexual harassment is a complex issue in nature. It engages us how social norms of the society looks at women, how people's perception and behavior carry certain constructed norms for gender. It may be an expression of power or desire or power, or it can be both. It is the policy of all workplaces that all employees will enjoy a work environment free from all forms of discrimination, including sexual harassment. In order to understand the issues of the sexual harassment at the workplace, we must pay attention to prevent socio-cultural issues of the gender and sexualities and how it impacts upon the status of women. How do we define then sexual harassment? Let me explain the definition. Sexual harassment can be seen as a legal and psychological occurrence. There is not a simple or universally accepted definition of sexual harassment. Feminist or women's studies, as well as the women's movement or the women's group across the world, made several attempts to discuss the concept of sexual harassment from a different perspective. For this purpose, sexual harassment include such unwelcome sexually determined behavior, whether directly or indirectly. It can be a physical contact and advances, it demands or requests for sexual favors, it can be sexually colored remarks, showing pornography or any other unwelcome physical, verbal or non-verbal conduct of sexual nature. A demand or request for sexual favors, sexually colored remarks, showing pornography, any other unwelcome physical, verbal or non-verbal conduct of the sexual nature. So, where any of these acts are committed in circumstances where the victim of such conduct has reasonable appearance, that is in relation to the victim's employment or the work, whether she is drawing salary or honorarium or voluntary, or whether in government, public or private enterprises, such as conduct can be humiliating and may constitute a health and safety problem. It is discriminatory when the woman has reasonable grounds to believe that her objection would disadvantage her in connection with her employment or work, include recruitment or pronunciation, or when it creates a hostile work environment. Adverse consequence might be visited if the victim does not consent to the conduct in the question or raises any objectionable therefore. Therefore, while describing the sexual harassment, we feel that how woman perceives an action is more significant than seated intended of the men. Let us understand what is meant by the conduct of the sexual nature through illustration at sexual harassment at workplace. Now, the verbal sexual harassment, asking for demanding sexual favors, making sexual or obscene comments, jokes or proposals, singing obscene songs, discussing commentating on women's personal issues such as appearance, marriage, pregnancy, etc., saying something sexually demeaning or humiliating, unwanted phone calls, etc., which falls under that. The non-verbal sexual harassment means certain leering, whistling, showing pornography, sexually explicit material, then incidentally exposing body part, smoking, licks, blowing kisses, These are some of MMS, emails, letters with the sexual propositions, material conduct that makes a woman feel uncomfortable sitting in an obscene manner. The third form would be in the nature is the physical sexual harassment, which I already spoke, but I will emphasize again: physical conduct or advances, unwanted touching, grabbing, holding, pinching, rubbing, blocking a woman's path, or concerning her, sexual assault or attempt to molest her. Now the forms of sexual harassment at workplace needs to be understood very carefully. The first form is quid pro quo sexual harassment. Now quid pro quo is a Latin phrase meaning something for something. Quid pro quo sexual harassment refers to demand of the sexual favors that threat of adverse job consequence if the demand is refused. The occasion when an employee submission to unwelcome sexual conduct become an explicit condition of the employment, or when personal actions such as promotion and transfers are determined on the basis of an employee response to such conduct. So quid pro quo sexual harassment favor is a precondition to the employment, increment, promotion which falls under that. This means that a woman would get benefits of being employed or promoted, or get an increment or rise in a grade or academic acknowledgement or recommendation only if she concealed to be a harassment. In other words, the consent to the sexual acts was not freely given by the woman. She consented under the pressure that she could lose the rightful benefits if she did not concede to the same. The second would be retaliatory, which includes refusal to provide the sexual favors, results in the backlash against the employee. This could be in the form of giving low marks, failing the student in an academic institution, or denying increment or promotion, professional opportunities to the woman in the working environment. The third would be the hostile working environment. Workplace environment will become sexualized to an extent that the employee's ability to work is affected. This is where the perpetrator may not be directly harass the woman, but he may put up the gender insensitive posters, insist on gender insensitive computer screens, display pornography, or say lewd jokes loudly, and so on, which marks the extremely uncomfortable for women to work in that environment. Now, also one has to understand the some of the illustration. I would explain here by giving the example. At an interview for determining increment and the promotion, B, the immediate superior of the A, started posting question to A about her sexual history and preferences of the sexual act. It was implied that if the A did not answer this question, B would not recommend her for increment or promotion. She found the line of questioning undesirable. B has committed quid pro quo sexual harassment. Now B, an employer, makes a female employer, stay late in the evening at the office on the pretext of the work, long after all other workers leave the office for the day. He would then find excuses to sit near her and suggest that they could go together to watch a film. A felt uncomfortable and found the sexual advances unwelcome, so she refused to go out with B. B threatened to dismiss her from the job if she does not go out to the movie with him. B has committed retaliatory sexual harassment. Now the B, the principal of the college, calls a girl student to his cabin repeatedly and on the film's pretext to discuss the student in his cabin, he puts up the pornographic pictures of the woman, which makes it uncomfortable for the A to even step into the cabin. B has sexually harassed the A by creating the hostile working environment for her. So let us know about the legal provisions in India. The Constitution of India ensures gender equality by making it a fundamental right. Fundamental rights are enshrined in the Part 3 of the Constitution. When fundamental rights are infringed, the natural basic human rights inherent in the human beings are violated. In the event of the violation of the fundamental rights, the aggravated person can move to the Supreme Courts and the High Courts under the Article 32 and 226 respectively for restoration of these rights. The relevant article confronting constitutional rights upon women are as follows. Article 14 ensures equality before law and equal protection of the laws to every person. It is not only prohibition, discrimination, but also makes various provisions for the protection of the woman. 2. Article 127A provides that the same shall be discriminate against any citizen on the grounds of only of the religion, race, caste, sex, place of birth, or any of them. Article 1273 empowers the state to make special provision for the woman. Article 16 guarantees equality of the opportunity for all citizens on the matter relating to employment or opportunity to any office under the state and forbids discrimination on the grounds of only of the inter-allied sex. So Article 19 ensures inter-allied to basic freedom, freedom of speech and expression. Article 19(1)(a), freedom to practice and profession or to carry out our occupation, trade or business. Article 19(1)(g). So Article 21 stipulates that no person shall be deprived of his and her life or personal liberty except according to produce established by law. Women workers have the right to lead dignified and honorable life with liberty. Article 23 guarantees the right against exploitation. It prohibits traffic in human beings and other similar forms of forced labor, makes contravention of this provision to be often punishable under law. Such violation therefore attracts the remedy under Article 32 for the enforcement of those above mentioned fundamental rights of the woman. In addition to these fundamental rights, Part 4 of the Constitution, which incorporates directive principle of the state policy and also ensures dignified life to working women. The important provisions are Article 39A ensures the citizen men and women equally have the right to adequate means of livelihood. Article 39D states that there will be equal pay for equal work for both men and women, and Article 39C states that the health and the strength of the workers, men and women, shall not be abused. Article 42 ensures that the state shall make provisions for securing just and human condition of the work for maternity relief. Article 271AE makes a fundamental duty of every citizen to renounce practices derogatory to the dignity of woman. There are the guidelines to be followed by all three organs of the state: legislature, executive and the judiciary, that are committed to make, interpret and enforce law. Indian Penal Code provisions related to the sexual harassment. The Indian Penal Code IPC, which remains law for the punishable of the offences committed within India, lacks specific provisions to deal with instances of the sexual harassment of the woman at the workplace, and eventually that one would see that the 2013 Act of Sexual Harassment at Workplace came into enforced. So, except for the certain section in the IPC such as 293. So, section 327 also is dealing with the assault or the criminal forces, but then eventually that the ways in which that the feminist movement engages with this, like for instance the Factories Act of 1948, Plantation Labor Act of 1927, Mines Act of 1927, Maternity Benefit Act of 1961, Beedi and Cigar Workers Conditions of the Employment of the Woman, which came into existence Act 1966, Equal Remuneration Act of 1976, then Incident Representation of the Woman Prohibition Act of 1987, Delhi Prohibition of the Eve Teasing Act came into existence in 1988. So there we have a number of provisions in the Indian Penal Code which came into existence. Now I would just emphasize on the Vishakha judgment in India when the Bhavri Devi case had happened. The Vishakha judgment in India is the role of the judiciary assumes great importance in dealing with the cases of the sexual harassment. In the absence of the enacted law to provide for effective enforcement of the basic human rights of the gender equality and guarantees against sexual harassment and the abuse, more particularly against the harassment at the workplace, the Honorable Supreme Court while dealing with the Vishakha versus the state of Rajasthan and the others, AIR 1997 Supreme Court 3011 has laid down the guidelines and the norms that should be observed and all workplaces or the other institution until a legislation is enacted in this regard. Now, I would quickly talk about the Bhavri Devi's case as a case study to make you understand what was Vishakha judgment. Bhavri Devi was a Dalit woman who worked as a Sathin, a grassroots work employed by the Women Development Project run by the government of Rajasthan. In discharge of her responsibilities at the work, she would go from village to village and prevent child marriages. In 1992, when she stopped a child marriage in the village, the upper caste men who were in favor of the child marriages decided to teach her a lesson and gang raped her. While her gang rape led to a criminal trial and that resulted in acquittal of the accused person, Banwari Devi, which is her name also, Banwari Devi's rape case also became a flashpoint for the women's movement and demanded the protection from the employment for discharging their responsibilities at work. A non-governmental organization by the name of Vishakha filed a public interest litigation in Supreme Court seeking guidelines in this regard. So guidelines issued by the Supreme Court judgment in the Vishakha versus state of Rajasthan in the 1997, and one would see the landmark judgment observing that the sexual harassment at the workplace as a violation of the woman's fundamental right to pursue a occupation or the profession of her choice as guaranteed by the Indian Constitution. This is because she is deprived, a safe working environment should be given. A Supreme Court also emphasized that right to life with the dignity. So the primary responsibility of ensuring such safety and dignity was through a suitable legislation by the legislature and the creation of the mechanism for its enforcement. However, as a gap arrangement, till such law was passed by the legislature, the Supreme Court laid down some guidelines at that point of time that should be followed with regard to the sexual harassment at workplace in order to protect women's rights. The guidelines also laid down the employee's responsibility for taking due steps to prevent, prohibit and redress grievances of the sexual harassment by establishing sexual harassment complaints committee And eventually we see that in 354A of the Indian Penal Code, the sexual harassment was a criminal offence, and in 2013, and when Nirbhaya case happened, it becomes a punishable offence, and 354A of the Indian Penal Code IPC was included. It includes sexual offences in public spaces such as roads, trains, buses, etc., as well as the private spaces such as educational institution, workplace. So therefore, sexual harassment of the woman at workplace provision, prohibition and redressal act of 2013, after 16 years of the battle, one would see that, if we look at Vishakha judgment was pronounced, and then the huge gap between them to Nirbhaya case, in 2013 one would see the Sexual Harassment of the Woman at Workplace Act was passed. So it has been enacted with the stated objective providing protection against the sexual harassment at the workplace. I would just simply conclude by saying that in this act, that the ways in which it has been operated, it provides more freedom to women, and one can approach under the IPC, and therefore in this lecture what I tried to discuss is that how at several levels the legal intervention was done by this thing, what is the meaning and understanding of the word sexual harassment, and how that we cannot define that at a larger level, but one can try to make it understand that how sexual harassments have been happening at several levels, what kind of forms are there, how one has to understand this debate, and what a long journey the feminists have fought. If we look at the Vishakha judgment and then the 2013 act which came into existence after the Nirbhaya rape case in 2013, and Justice Verma's contribution, immense contribution to that. So thank you.